You're listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
To another episode of the Legacy Lawyer podcast. This is Nathan, and joining me today is another attorney in our office that you've met on previous podcasts, Brian Edwards.
Hello.
How's it going, Brian?
Pretty good.
Good.
Yeah.
So, before we start, I'll give a standard disclaimer. We are both estate planning attorneys. We do the kind of work that we're going to talk about today, but the purpose of our podcast is for edutainment purposes only, education and entertainment. So please don't take anything we say as legal advice for your specific situation, and seek out a qualified, licensed estate planning attorney in your area for assistance with your specific case. Having said that, Brian, I think we have a really interesting topic today.
Yeah.
It comes from a couple of cases that we've worked on in our office. The names and identities of these good folks have been changed around so that we protected confidential information. But we're going to give you some of the facts and some of the juicy details. And as usual, this is going to be a discussion of how seemingly innocuous actions turned into big mistakes that cause people a lot of heartache, and then we'll contrast that with a case where things were done right, and see if we can leave you with something that's useful that you can utilize, or you could share with people in your life that are facing similar types of situations. Yeah. So Brian, tell me about this case. I understand we represented a gentleman, and this involves the deed to a house.
Correct.
Tell us the facts of this case.
Yeah. So our client, gentleman, he had a girlfriend. They wanted to live together. They were not married. They decided to go and buy a house together. We're happy for them, great. That sounds like a great plan. The deed that was drafted for them just listed their names only. Didn't say joint tenants. And under current law, that could be an issue, or at least the law at the time when they created the deed. That was what happened.
We actually, trying to remember who I did this podcast with, but if you go back 2 or 3, 4, 5 podcasts, we did a podcast on a change in the law relating to how joint tenancy can be created in a deed. And so in that podcast, you would learn that in order to create joint tenancy, especially it sounds like at the time this couple was purchasing a home, you would have had to use some pretty specific language, and specifically state that it was supposed to be joint tenants with full rights of survivorship,
right?
Where they weren't a married couple,
right.
So then just listing their names at that point in time, what did that create?
Create a tenancy in common,
which means
basically if somebody were to pass away, well, they both own 50% of the home and they own it separately. So when somebody passes away, it doesn't automatically go to the other owner. It goes to whoever is listed in an estate plan, or if there's no estate plan, is listed in the state statute. So it's not an automatic transfer to the other owner.
So they were boyfriend, girlfriend living together, owned a house together as joint tenants, as tenants in common, means they each had a separate 50% ownership in the property.
Correct. They did eventually get married, which is great. But they didn't update the deed or anything. They assumed it was correct and everything was good to go. And I can understand why. Why would you think to update your deed? That's not one of the documents that really comes to play, but it should be. It should be one to make sure you verify if something like that happens in your life. But anyway, long story short, also the no estate plan was done in this situation, and then the girlfriend, now wife, passed away, and she had kids from a previous relationship as well. And our client found out that all of a sudden that 50% that was owned by wife, he now has to figure out how it's supposed to be divided and shared between these kids that wife had. That relationships aren't the best, so they're trying to figure out, okay, how are we supposed to divide this at this point? He thought he was going to get the entire house. It's going to be his house, and found out that all of a sudden portion of the house through state statute doesn't go to him automatically.
So he probably had a discussion with his wife, and maybe even prior to being married, where they said, okay, we're going to put our money in. We both own this house. If something happens to one of us, the other one has the house.
Correct. They thought it was good. They thought that's what they wanted. That's what they intended. Just the documents didn't say it.
Did he find out about this problem in your office?
He did. Yeah. When he came into our office.
Don't you love when
we mentioned it? Yeah.
Don't you love when you have to be the bearer of that kind of news?
Oh, those are fun days for sure.
So brutal.
Yeah.
And what was his reaction?
Dumbfounded, disbelief. Can we fight it? Is there any way? What can we do? Just how do we get around this situation? And it's a difficult one. There's really nothing that, I mean, unless you want to try to fight a law that was, entered in by the state legislature. I mean, you can try to do that, but like there's just nothing that we could do other than, okay, let's try to make it so you can get the best possible outcome dealing with, the wife's other kids.
Yeah. And I have had situations with other clients. In fact, I think we've also done a podcast. This would have been a long time ago, about a client of mine that was in a similar situation. But unfortunately they were married, and not unfortunately, they were married. They were married, and unfortunately through a refinance, either the lender or the title company or whoever drafted the new deed after the refinance, it was put back in their names, not as joint tenants like it was before the refinance. It was tenants in common.
Wow.
In that case, we had a really good outcome because, we ultimately had a really good outcome. Not without a ton of stress and strain and worry on the part of my client, because she was going to be approaching stepdaughters who gratefully she had a good relationship with. And she was already, like, the way she found out is we were in the process of putting together a trust for her because she had just lost him. And it was a blended family. She had already included them in her trust as beneficiaries because she viewed them as daughters, and she felt an obligation to her husband to include them. So that kind of, that made it, that's better facts when you're going to the stepkids and saying, would you mind disclaiming? Because really that's what the only option is, to go to them and say, this is not what was intended. You do have these legal rights, but would you be willing to disclaim? And in this case, both daughters said, absolutely. We want no part of that house. We want her to have it. It's what our dad wanted. And they both signed disclaimers. And so we were able to eventually put that entire house into our client's trust, and she owns it without any remaining legal issues. And that turned out well. Doesn't sound like that's how this one's going.
No, not at all. Not at all. You just never know what's going to happen. And when there's blended families, it is critical critical that you have the estate plan set up ahead of time. Not to say every blended family has its problems, because some are wonderful and great, right? But you just never know how people are going to react upon death. And it's because our client, I mean, the relationship was there, it was good, and then the death happened. And
so what's happening with him is that, are her children contesting it, or is everybody lawyering up? What's happening?
Her children are contesting it. They want their portion. They want to take a portion of the house. So they're lawyering up right now. The last I heard is they're talking about, you know, what's included in the estate at this moment, which is the house. That's the big one I mean, most people, their biggest value is their house. Not for everybody, but that's the big one here. So they're just trying to figure out that, but everyone has a lawyer and they're working through it.
Well, and the problem here is I don't really see an out for your client, for our client, because the law is pretty cut and dried in this regard. Like, those kids have rights.
I agree. It's just trying to mitigate those damages, and if you want to think of it that way, or just what's the least that you can give them to make them happy, and still hold on to what you can do. Can you give them something else besides the portion of the house, right? And just try to negotiate what can be done before, you know.
It's going to be a settlement.
Yeah.
It's either going to be a settlement or there's going to be a partition eventually, and that house will have to be sold to get those parties made whole.
Right.
Super hard for the widower.
I agree. I mean, you never know what a judge is going to do, and in a situation like that, hopefully the facts stack against, like, for him, and that a judge will be sympathetic and say, you've owned this house for 25 years.
Even if they get a sympathetic judge, you really feel like there's even a path forward as the judge, I feel like the judge's hands are tied. I
think you're right. I actually agree with you. I think his hands are tied unless the judge is like, is there anything else you can give him besides trying to sell this house? Well,
but that's a negotiated settlement.
I agree. Yeah, that's true. That's a fair point. So if it gets to the point where the judge has to make a decision, that's gonna be a really tough decision to swallow if he says, hey, you gotta sell the house.
So when they bought the house as an unmarried couple, do we know anything about, like, were they counseled on how to set up the deed, or do we know who set up the deed, or we don't even know? They probably don't even know that.
They don't remember, at least. I think it was a mortgage company, just whoever's helping them with the purchase of the home. Again, they were under the assumption that everything was going to be okay, that if they passed away, the other one would get it. I mean, 25 years ago,
that's how many years ago this happened?
Yeah.
So here's the thing. I guess maybe what we can take as the lesson here is it's pretty hard to say to people, like, as soon as you close on a house, hire a lawyer and have them review your deed and make sure it's right. I mean, it's not a bad idea.
Right.
And it wouldn't be that expensive to do. And just have somebody interpret the deed and tell them, like, and ask questions like, if something happened to us, what would be the outcome? Because if they had learned that they were tenants in common and that the death of one would require a probate or would give rights to the children of the other person in the event of a death, maybe they would have made some changes right then. But I guess the bigger, more obvious lesson to take from this is, how long had they been married approximately? Like, they were together as an unmarried couple. How long had they been married?
I think they've been married for about 15 years.
Okay. So I think the lesson is, if you're going to cohabitate, you should still put an estate plan in place, because we do estate plans all the time for unmarried couples. And they work great, and they can be built in such a way that they address all the potential problems of somebody dying in a situation like that. Right.
Correct.
But then, so they had at least two opportunities to fix this, right? Once when they decided to cohabitate, and then definitely again when they decided to make it legal as far as the relationship's concerned. If you're getting married, there's no getting around that you should have an estate plan. So 15 years ago, when they tied the knot and made it official, one of their first, priorities after that wedding was over and the festivities had ended and the dust had settled was, okay, now we're a married couple. We both have kids from previous relationships, and we have some shared assets after these years that we spent living together, 10 or so. We need to go in and get an estate plan in place and have an attorney advise us. So that would have been a time to find a trusted advisor, a good qualified estate planning attorney who understands blended family situations, and to get the documents in order. If they would have done that 15 years ago, this situation would not have developed.
Right. And I can't tell you how many families we come across that are blended families these days. It's common. It's very common. And I think, even if I'm a listener of the podcast, I'm in a blended family, we got remarried 20 years ago or whatnot. I think it's still a good time to be like, I have a blended family. We should probably sit down and with a trusted advisor and figure out, okay, is it set up how we want to? And if not, what do we need to change? And really work through that. Make sure we get that estate plan in for sure.
Sorry, I didn't mean to interrupt you.
You're good.
I totally agree. Any married couple hearing this, if you don't have an estate plan, you should have an estate plan. Any married couple in a blended relationship where there's kids on both sides from previous relationships, your need for an estate plan is like on fire.
Correct.
There are a whole host of additional complexities and potential problems and pitfalls that need to be addressed in your plan to make it so that you don't end up in a situation like this poor gentleman who's now going to be at war with his stepchildren over the house that he lived in with his now late wife. He's grieving her, and he's also got this to deal with. So this is not a situation anyone wants to find themselves in. But unfortunately, there are, we could probably walk from here to the grocery store that we can see over the freeway and run into 5 people, and 4 of the 5, if not all 5, would be without the proper type of plan, right?
I agree with you. Yeah, for sure.
So if you're listening to this, you're probably somebody who's interested in avoiding these kinds of problems, and please don't sit on your hands and hear this and then not take action. I'm going to contrast what we've just talked about with a case that I'm handling right now where kind of the polar opposite. And I will say that this couple, just by virtue of what they do for work, I think they would be a little bit more knowledgeable than a kind of more average couple that doesn't work in any of the fields that relate to this. But they come from out of state. They purchased a home together here in northern Utah, and they've done some things right that I think our listeners can learn from, that are very that are kind of a stark contrast to the situation that you just talked us through. Mm-hmm. First of all, they both have separate estate plans. So they've decided that they're an unmarried couple, and I don't think they ever plan to get married. But so in their case, they've decided to completely keep everything separate in terms of their financial lives. And so what they've done is they both.
If you don't mind, sorry to interrupt. That doesn't work for everybody, obviously. For this family, for sure, that's a good option, and it sounds like it's good for them. But that obviously doesn't work for everybody, and that's okay.
I agree. Yeah. It just happens to be that their specific circumstance are that they've decided to keep everything separate.
Yeah.
And to your point, even if they hadn't decided to keep everything separate, they could still have an estate plan that addressed all these issues, that incorporates maybe more of a blending of the assets, right?
Yeah. Yep.
That could be done.
Sure.
So you're exactly right. But so I guess my point is not that they have an estate plan where they keep everything separate and that's the good idea. The point is they have an estate plan.
Yeah.
Right? So the fact that they both have estate plans means that they already started out on a better footing by having addressed these issues and having their affairs in order. Now, when they purchased the home in Utah, that was kind of the first time that they blended some of their assets into a single investment. So what they retained us to do was put together what's called a separate property agreement, which is sort of like a prenup of sorts. It's a marital agreement where rather than just relying on the default statutes and what the laws say happen in a given situation, they want control over what happens if they separate, what should happen to the money that they've each respectively invested in this home. If one of them dies, what happens? If they both die together, what happens? So that agreement addresses all three of those scenarios in very clear fashion and outlines exactly what should happen if they separate.
Mm-hmm.
Then it's already a done deal. We already know there's not going to be any legal proceedings because they've already agreed up front what should happen. If one of them decided to try to engage in some sort of a lawsuit over it, that lawsuit's going to come to a screeching halt because the other spouse would pull out, or the other partner in this relationship would pull out that agreement and say, we've already agreed in advance on how this is going to work, and the court would enforce that agreement. They've also, made it very clear what would happen if one of them passes, and what would happen if both of them passed together or in such close proximity that they couldn't deal with the situation while one of them was still living.
Yeah.
So that is kind of the polar opposite of what you're dealing with. Now,
right.
We haven't thankfully had either one of them pass or the relationship end or any of the triggering events for this agreement to see how it would play out. But you and I both know just from experience in dealing with these cases that when things are set up in trusts, in other estate planning documents, in prenups, in property agreements, when the legal work has been done, the outcomes are so much cleaner.
Correct. Yeah, for sure. And it just comes down to, if we're going to try to say that any of these documents that you just listed should be unenforceable, that's going to be I think it's going to be a hard bar to try to fight and try to claim against in the court.
Yeah.
The judge is going to look at it and be like, they signed this. What are we, what are we here for? And I think it's going to be a really hard bar to try to terminate any of those.
Yeah. So, I think what you're doing by putting all those agreements in place is you're kind of creating a presumption that things are going to go the way that you planned. Of course, unexpected things can pop up. There might be wrinkles that we don't know about yet that could cause problems. But I would say if you were to take, 10 cases where the documents are in order and a qualified attorney or multiple attorneys have been involved and coordinated that plan, that 8, maybe 9, maybe all 10 would end in a successful outcome for the family, meaning what they intended is what happens.
Yeah.
And maybe just, there's that outlier case here and there that could come in with some fact that wasn't accounted for and cause the kinds of problems that are happening in the case you're dealing with. But But overall, I'd say, and I think listeners could just talk to people that they know and get a sense for, seeing a very different outcome from people that had no plan versus those that had a plan.
I agree. Wholeheartedly, yeah.
So it's a message that we beat to death in all of our podcasts, and that is, you want to work with a trusted advisor. You want that trusted advisor to be versed in the law that affects your situation. You want them to have experience dealing with the particular type of case that you're dealing with. So if you're a blended family, you would want to know what is this attorney's experience planning for families that are blended. How much, what part of their practice is planning. You would want somebody that has a strong emphasis, if not a specialty, in this area of law. And then, you want your plan done in a way that doesn't really leave anything to chance.
Yeah.
So if that's not you and you're listening to this and you're in any of the circumstances that we have just mentioned, please take some action. Be in touch with us. Be in touch with someone in your jurisdiction or close to your home, and make sure you do some good screening to ensure that you're working with the right type of attorney, not just in terms of the kind of law they practice, but also their temperament, their approach to client interactions, what kind of follow-up and continuity plan do they have built in to the planning they're going to do for you, because just doing documents once and never looking at them again is not necessarily going to lead to a successful outcome.
That's right.
So you want somebody that, in this case, in this couple's case, if they had done their planning when they decided to move in together and buy a home, that would have been awesome. And then to be able to call that attorney back 10 years later and say, okay, now we're going to get married. How does that change our plan, and what do we need to update in our plan to account for that?
Right.
Very important new development. And that's what you're looking for, is a firm that's going to still be there 10 years from now when the circumstances of your life have changed and you need your plan to be updated to match those circumstances.
I agree. And I agree with that. I don't know. I'm happy to say that's us, Nathan. I think that's us.
Nodding his head, yes, that's the right thing to do. I agree.
Yeah.
Hey, Brian, thanks for sharing your experience with this case and your expertise. Thanks for all the good work that you do for our clients here. And thanks, everybody, for listening. And we will catch you on the next one.
That's right. Happy to be here. Thank you.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.